This is the second part of our discussion on legal Latin. The first term is pro tempore. I think you've been hearing this particular term, particularly in Congress. No? So we have a speaker pro tempore. Pro tempore means for a short time. So temporary. So as is used in our jurisprudence in law, here's an example. Under the rules of the Senate, the president pro tempore shall serve as acting president until the Senate shall have elected a new president. Okay. So a temporary president shall serve as acting president until the Senate shall have acted or shall have elected a new president. So in we can probably imagine a situation in the Senate where the president of the Senate would have died, and there is a president pro tempore who shall serve as acting president. So in the meantime, for a short time. So that is one meaning of the term pro tempore. Another term is in personam. Okay, so this is a term used to define certain actions. In persona means a legal action against a person. Okay. An example in our jurisprudence, in one case, in personam was used in this way. A labor contract merely creates an action in personam and does not create any real rights which should be respected by third parties. So in personam cases, okay, between the employer and the employee, that the case being the action being in personam is between them only. It is not a decision or a decision that would affect the rights of other persons. It would only affect them. Another term, ipso facto. Ipso facto. So it is defined as by this fact, or the fact itself shows this to be true. Okay. So in jurisprudence, this is how it was used under Section 15 of Commonwealth Act 473. An alien woman marrying a Filipino, native, born, or naturalized, becomes, by this fact, ipso facto, a Filipina, provided she is not disqualified to be a citizen of the Philippines under Section 4 of the same law. Okay, so by the fact that she married, by the fact that she married a Filipino, an alien woman becomes a Filipina. And this is still valid law. Okay, so a foreign woman marrying a Filipino, and she does not have any of the disqualifications, she becomes a naturalized, or she becomes a Filipina, okay, by the mere fact of her marrying a Filipino. And this Filipino is either a natural born Filipino or one who is naturalized. So meaning an Indian who became a Filipino, okay, by naturalization, and marries a foreigner, by that particular fact of marriage, that Filipina or that foreign wife becomes a Filipina, no? By the mere fact that she is married to that naturalized Filipino, okay? But ipso facto, by that fact. Then we have in loco parentis, okay, acting in place of a parent. So how it was used as a teacher, petitioner serves as an example to his pupils, especially during their formative years, and stands in loco parentis to them. In loco parentis. So there was a question previously on how is it different from parens patriae, no? So in loco parentis, it refers to uh, individuals, no, directed by the court or by operation of law, no, becoming uh, the substitute parents of minors, while in parents patri, okay, where the state, okay, has the responsibility to act as the parents of its people. Okay, so it is more generalized, while in loco parentis refers to certain individuals and certain people. Okay. Then we have per curiam. Now you would encounter the term per curiam when reading decisions. Okay. If you read the annotated or the Supreme Court reports annotated, or the uh, Philippine reports, no, where our jurisprudence is printed, or our jurisprudence, no, the case decisions of the Supreme Court are printed. Uh, Sometimes, no, it begins with the term per curiam. What does per curiam mean? No, a decision correctly made by a court, which can be used as a precedent. But uh, in our jurisprudence, no, per curiam is used, no, to state or where the judge or the justice who writes the opinion of the court or the decision, okay, does not wish to be identified, okay, and the court would say or would state that it is per curiam, okay, that it is a decision made by them, okay. So under the rules of the Supreme Court, this was how per curiam was used, no, or was introduced, no. So unless otherwise requested by the member assigned to write the opinion of the court, the decision or resolution shall be rendered per curiam. Okay, per curiam. Then doli capax means capable of committing a crime. Okay, the capacity of a person to commit the crime. That individual has the capacity, and therefore, no, incurs liability. Because he has capacity, he incurs liability when he or she commits a crime. So here's one, no, under Republic Act number 9344, where the principle states that persons 18 years old and above are doli capax and can be held fully liable for offenses that they commit. Okay. So in the negative, no, we have doli incapax, meaning that the person is not capable of committing a crime. A crime is committed, but whether he's liable or not is dependent, one, because of his of certain conditions like age, like a person who is insane. So a person who is insane commits an act which would be a crime when committed by a person who is sane, okay, is said to be doli incapax. Okay. So doli capax is the capacity to commit a crime, the capacity that he can be held liable for such offenses because he has such capacity. Then we have onus probandi. This term means the duty to prove that what has been alleged in court is true. In other words, the burden of proof. Okay. So a person, no, or the party who alleges has the burden of proof, no, to prove such particular allegation. In one case, it was used in this way. In an illegal dismissal case, the onus probandi rests on the employer to prove that its dismissal of an employee was for a valid cause. So let us make the substitution, no, the burden of proof. In an illegal dismissal case, the burden of proof rests on the employer to prove that its dismissal of an employee was for a valid cause. Onus probandi. Then we have obirime fide. Okay, obirime fide means in total good faith, a state which should exist between parties to some types of legal relations. So, uh, in utmost good faith, obirime fide. How is it used? No, Switzerland insurance relied on the value of the cargo declared by the insured on the basis of the principle of obirime fide. In insurance contracts, they are considered to be contracts obirime fide, no? Where there is an expectation of the parties to be what? That they entered into the contract of insurance in total good faith, and therefore their statements or allegations as to their status, as to their health, no, shall be accepted by the insurance in under the impression that the person who is making that allegation is making it in good faith. Then we have de jure, a situation where legal title is clear. So again, no, we have de facto, where which we discussed in part 1, and now we have its counterpart, de jure. Okay, so in de jure, unlike in de facto, here in de jure, the legal title is clear. Okay, there is the basis for, or a legal basis for such status, no, like a de jure official, okay, or a de jure government. Okay. It has been repeatedly held that occupancy and cultivation of an agricultural land will not, by that particular fact, make one a de jure tenant. Just because you are there tilling the land does not mean now that you are, by legal definition, a tenant. Okay. So de jure. Then we have non compos mentis. Well, mad or not completely sane. So, popularly meaning of the word crazy, it is not synonymous with the legal terms insane, non compos mentis, unsound mind, idiot, or lunatic. So, crazy, no, is not synonymous with non compos mentis, apparently. Okay, because crazy can be an expression. You're crazy. No, you're crazy for doing that. That is an expression, but that particular term crazy does not mean non compos mentis. Non compos mentis refers to the situation where the person, no, is not sane. Okay, how would we describe a person who is not sane? No, that he does not have the full faculties, no, his full faculties, his full mental faculties. That he might be living in a world that is created in his mind and does not perceive the world as we perceive it. Then ad litem. The term means referring to the case law. Okay. How is it used? Now, since Benedict was a minor, his natural mother and guardian ad litem, Shirley Arevalo, filed the complaint on his behalf. Okay. So for that particular case, the mother is the guardian ad litem, okay, referring to case at law. Okay, so referring to that particular case, or yeah, it is in reference to a case. So a guardian for this case, for that case. Then bona vacancia. Bona vacancia, meaning with no owner or no obvious owner. How was it used? No, in the United States, abandoned articles such as those thrown away are considered bona vacancia and may be lawfully searched and seized by law enforcement authorities. Okay, so this means that those things which are thrown away is can be searched by authorities without the necessity of um, obtaining a warrant, no, for those articles to be searched. Okay, because they are what? There is no obvious owner or uh, you know under that particular definition. Then mens rea. Again, you've learned this in criminal law. Mens rea is the mental state required to be guilty of committing an offense or a crime. So criminal intent or mens rea must be shown in felonies committed by means of dolo, such as falsification. So it is the criminal intent, mens rea. Then quid pro quo means an action done in return for something done or promised. Okay, so I scratch your back, you scratch mine. There is no unjust enrichment where the transaction is quid pro quo, value for value. Okay, so in certain agreements or contracts where one takes, for example, a one benefits from it. Okay, if there is a contest as to one stating that you took advantage, no, you unjustly enrich yourself because of that particular agreement. But because the transaction is quid pro quo, no, value for value, uh, there is no unjust enrichment in those cases. Then we have the term ab initio, meaning from the beginning. A contract that violates the Constitution and the law is null and void ab initio and vests no rights and creates no obligations. Okay, so void ab initio, void from the very beginning. You would encounter this term in marriage, okay, in void marriages, which are void from the very beginning. Then in rem, meaning a legal action against a thing. So this is in reference to the previous discussion in personam. Okay, this is the counterpart in rem. How is it used? As an action in rem, the gist of the replevin action is the right of the plaintiff to obtain possession of a specific personal property by reason of his being the owner or of his having a special interest therein. Okay, so it is the contest is as regards possession of a thing. That is the purpose of a replevin case. Then actus reus means an act forbidden by law. Okay, so it is the act itself which is wrong, no, which is unlawful. Because for a crime to exist in our legal law, it is not enough that mens rea be shown. There must also be an actus reus, meaning that even if there is an evil intent in the mind of an offender, it is not a crime to think wrong, to think of evil acts. But if it is not outwardly manifested, then it is not a crime. But once you act on your evil intent, then that becomes a crime. So it is not wrong to, in your mind, no, the fact of or the evil intent of killing another person. But it is not a crime to think ill of another person. But once you kill that person, which is the actus reus, then it becomes a crime. Then doli in capax, as we've mentioned, no, this is the opposite of doli capax, so not capable of committing a crime. So under Republic Act number 9344, persons below 15 years old are doli in capax and do not incur criminal liability. So if a child is below 15 years of age, okay, even if the child committed the act, it is not to be considered one a crime because the person who committed the act is not capable of committing it. Okay, so doli inca pax. Then corpus delicti, meaning the real proof that a crime has been committed. In criminal law, some would describe this as the body of the crime. Okay, but it is not. Yes, the body of the deceased person can be, okay, can be the corpus delicti, but not all offenses would refer to a body. Okay, so corpus delicti is the proof that a crime has been committed. So it has been defined as the body or substance of the crime, and it is, in its primary sense, refers to the fact that a crime was committed. Corpus delicti. And the term mala prohibita, an act which is not a crime, but it is forbidden. Okay. It is not a crime itself, but it becomes illegal or unlawful because there is a law that prohibits it. Illegal possession of regulated drugs is mala prohibita, and as such, criminal intent is not an essential element. Remember that the example that I gave for mala in se, okay, or yeah, um, where um, I'm sorry, in mala in se, okay, it is wrong. No, the act itself is wrong, okay, morally, okay, because of tradition, because of customs, the thing itself is wrong. Like murder, killing another person is wrong by its nature is wrong. But when you possess drugs, for example, how can it be wrong? No, it would not have been wrong if there was no law that prohibits it. Similar with firearms. Okay, uh, is it wrong to carry firearms? If you merely carry it, what is wrong about it? It only becomes wrong because there is a law that prohibits it. That is the term, or why we have this term mala prohibita, differentiating it from mala in se. Then we have bona fide, in good faith. Bona fide. Marquez maintains that he has a bona fide intention to run for office and can sustain a nationwide campaign. Now, this is a case where Marquez was being considered a nuisance candidate. Okay, so some would pronounce it as bona fide, some would pronounce it as bona fide. It means in good faith. Okay, you also encounter these terms in international law as regards consular officials or diplomatic corps giving their bona fides to the accepting countries. No, ultra vires, meaning acting in a way which exceeds your legal powers. So beyond what is legally allowed for you to do, ultra vires. Okay, the contract is not ultra vires, but an act executed within the powers of the defendant's corporation in accordance with its articles of incorporation. So, if it is within your powers, then it is not ultra vires. If it is outside your powers, then it is ultra vires.